Express is brought to you by
Guarantee Trust Bank. Wouldn't you rather bank with us?
And welcome. Well, yesterday marked two major days in the history of Ghana. One was to do with the EC, and we discussed it, and the other one was the Supreme Court saying that there's no such thing as a non-bailable offense. Now you could be on two sides of the fence. There's one who's going to say, hooray, you have to grant me bail for whatever it is that I did. And there's the other man who's probably little girl has been raped and thinking, hold on, why are they granting him bail when my little girl has been defiled? Should we rejoice or should we cry? Either way, it's a major legal landmark in the history of Ghana. And who led it? It was led by my own friend Martin Pebu, and he started this 15th of February last year when he went to court and obviously told the judges that, look, I am not happy with this law, I find it too oppressive. He argued out his cases, and almost a year down the line they say, yep, I think you have a case, and therefore we have granted it. We're here to discuss it and find out, is it one of those that we have to rejoice, one of those that we have to cry? My name is Nana Ansakwa. This is PM Express, and it's a post Mother's Day program, and so I'll be giving you a whole list of mothers that I have to wish Happy Mother's Day to throughout the show. Indeed, I'm sure Mrs. Pebu would get a shout out on the Mother's Day as well. I'm going to take a break, and then when I come back, the conversation continues, and I really want to hear your take on this. It's 0560 800 000. 0560 800 000. I want to hear your take on this issue. Coming straight back. Much for staying tuned, and first of all, Happy Mother's Day to Nanessa Dansumisa, my first mother, and then Angela Dansumisa, my second mother, and then Nana Krantima Brooks, my third mother. Then I have Ya Verson, my fourth mother, and then overall mother, who's Nana Frakoma, the second, and then to Awodanswa, my wife. Happy Mother's Day to you. And as we're going along and have so many mothers, I'll be wishing all of you a Happy Mother's Day. You are indeed wonderful. Indeed too, Mrs. Pebu. Happy Mother's Day to you too. And with me in the studio is Mrs. Pebu's son, Martin Pebu. Brother, and then joining us on the phone later will be Francis Susu Xavier, a human rights lawyer, to discuss this issue. But Martin, what triggered this whole thing for you to walk to court?
Okay, I must indicate that it was a sense of frustration with the system. I mean, specifically, the oppressive nature of that law. You know, having practiced for a few years, I mean, it dawned on me that, look, this law was just so oppressive. And it's a common feeling at the bar, meaning that, we are confronted with situations in which persons are charged with murder, rape, defilement, all those ones in the category. And as soon as a client instructs you in respect of this case, then wow, bail is out of the question. You see, so each time you were instructed in respect of such a case, you felt frustrated because you knew that it was almost impossible, except where the person was exceptionally ill. It's not every ailment. It had to be very serious. Or except a situation in which he had already spent at least 2 years in custody.
2 years?
Yes, minimum. I can tell you, as of 2012, some judges could write that 2.5 years was not unreasonable delay. The law says that if you keep the person in custody, so even before this law was struck down yesterday, it had always been in the Constitution that if the person has been unreasonable, if the trial delays unreasonably, no matter the offense, the person should be granted bail. Yet there are decisions that we can show you even as of 2012, 2014, where judges have said that 2.5 years doesn't constitute a reasonable delay, meaning that somebody's dear one has been kept in custody for up to 2.5 years, and yet a court will look at it and say that the trial has not delayed. So all these together just spurred me up, and then I filed the case in February last year.
I am looking at the dangers that you've pushed all Ghanaians into. Because if there's a serial rapist out there, you know, he'll be granted bail and probably cause more mayhem because of Martin.
Well, on the contrary, I think this decision is very good. It's going to cause substantial change in our system. It's just going to bring us so much improvement to the system that I believe we'll be overwhelmed. Because what happens is that if we have evidence against this alleged serial rapist, then what happens is that as soon as the investigations are completed, maybe a couple of weeks or maybe a couple of months, and he's admitted to bail, and we have evidence against him, I suppose that the victim or the alleged victim and his or her family will pursue the police and the Attorney General to prosecute the case seriously, so that the case would come to an end, so that he will be found guilty, and then he will be sent to jail where he would properly belong. So on the contrary, I think that the decision is going to make everybody sit up, because people would not want to see those alleged rapists, alleged murderers, alleged narcotic drug offenders, and so on and so forth, walk our streets in such freedom. People would not want to see them in the streets. So if you don't want to see them in the streets, what would you do? You would pursue the trial. But hitherto, before the law was cancelled, the most painful thing is that we would take such persons and throw them in jail. I mean, well, we call it remand, but it's the same. Fiscally, it's the same jail facilities, though they are on remand. We kept them away, and then whilst they were in custody, the police investigators could go on leave, could go on transfer, could go on peacekeeping, and all this while people would be in remand, and their trials would not have started.
But is it like in rape cases? I mean, it's rape, so it's not bailable offense. It's rape. So, was it the police who decided that you can be bailed, or was it a court that decided that you can be bailed?
From the nature of the law, it was the court. The law said that the court shall not grant bail in those offenses. Okay. That was the general law. Of course, there are always some exceptions, but let's discuss the main point. The law said that you couldn't be admitted to bail for those offenses. And so that was it. It was a common refrain. So we would throw those people in. So
even if you came to court, you dare not apply for bail, just try and speed up the case? Or how then do you proceed? Okay. If I was your client, you know, being held for treason or something, you try to speed up the case, or you still try and see if there will be bail?
We often, I mean, the norm, the practice actually is that even though we know it's non-bailable, but you try. I mean, you do the best advocacy that you can, okay? The zealous advocacy that is expected of a lawyer. So it's normal practice to apply for bail, knowing that over 90% the application will be turned down. But there were a few cases where, even from the facts that the police read, if it was clear that this didn't look like bail, the judge could grant. I mean, if it didn't look like rape or murder or whatever that non-bailable offense was, the judge could grant bail. In legal parlance, we say where the facts narrated in court does not support the charge. But those ones were few, negligible. The larger majority, even for some judges, and it's true, you can't fault them. From the law, they could tell you that, oh, but the facts are not evidence. Okay, so even though there are mistakes in the facts, that doesn't mean they don't have a case. So it wasn't a clear-cut ground for getting bail. So the norm was that for those offenses, there was no bail. And even as of yesterday, at the time the judgment was being read, the CJ, in her concurring opinion, indicated that in Nsawam alone, there was between 200 and 300 remand prisoners who were in that category. In Nsawam alone. And that's just one facility. We haven't spoken about Ankafo and then the rest of the country. So you can imagine the problem we have. People who are on remand because those offenses were said to be non-bailable. And trust me, I can tell you on authority that a lot of them have spent years. In actual fact, in the past few years, there was this program that was brought called Justice for All. Yeah. It has helped to decongest the prisons a bit, and some of those offenders benefited, but a lot still remain in custody. So, since justice for all is not going to be operating for all time, it's good this law has been struck down so that for all time we will rely on the new position of the law to get bail.
So, I know the law says that everybody is innocent until you prove them guilty.
Yes.
So, per the old law, were you now being presumed guilty before innocent? I mean, how was it?
That is how it looked practically. So you are right, Nana. That is the answer you've given. So the reason for the decision in simple layman's language is that the Supreme Court is saying that a person is innocent until proven guilty. So if he's innocent, why do you keep him in custody for years? I like the way you've put it. So that is the simple rendition of the decision. Let's give meaning to the principle that a person, an accused person, is innocent until proven guilty. So from the nature of the old law, it was rather the reverse. Oh, we will consign you to prison until we prove that you are not guilty. And by which time we would have ruined the person. I mean, the state of our prisons is common knowledge to all of us. It's not the best, to put it, mildly. So we shouldn't lightly throw persons into remand custody.
What was was it where the Attorney General also brought lawyers to actually challenge you, or was it just you in front of a panel of judges, trying to convince them?
Surprisingly, the Attorney General brought lawyers to come and challenge, saying that no, the law was perfect. Yes. And it's interesting, the court threw out all the arguments that the Attorney General presented. Yeah. In the lead opinion, the court made it very clear that it didn't subscribe to the arguments brought by the Attorney General at all. They were totally thrown out. Yes, because, there are certain things, you see, this case is not for me personally. It's not for me personally. It's public interest law. It's for every Ghanaian. You remember a few months ago, our friend KKD, you see, he was in trouble.
Yeah.
Had it not been for ill health that he could prove, he would have spent a lot more time in custody. You remember Kwao Kese? Yeah, for a joint. He was in custody for months. He too, it was because of ill health. But my brother, there are a lot more, hundreds of people who are not celebrities, so they are not able to prove their ill health, and so they are still in custody. So it's better that now the law is being straightened for everybody. You don't have to prove ill health only in order to come out. If you are arrested today, and then naturally, we all expect that for the police to do their work, they should be given maybe a few weeks, at most a couple of months, almost 2, 3. I don't see, if you compare in other jurisdictions, usually these investigations, the time you are needed in custody for investigation shouldn't span more than 2, 3 months. So the court has brought our law in tandem with the international best practice, okay? And we should be happy for it.
The police will have to hold you for 48 hours while they do their investigations.
Yes.
After 48 hours, they then apply to the court to say, I need more time.
That's correct.
That still stands?
Yes. So that is it. So that's at the first hearing. We all, a lot of the time, I think as practitioners, we are used to it. We've grown used to it that if it's murder, rape, narcotics, and all those in first 48 hours, if we go to court, though as a lawyer, I'll be making an application for bail, but we also know that generally, considering how serious the offense is, it's normal for the judge to say, no, I will grant the police more time to go and investigate. That's why I said even up to a month, or maybe 2. But beyond that, no, with this new decision, we will fight it. If the trial judge is not granting it, we will go up.
So then after, let's say, 3 months, you can now apply that it's unreasonably long.
That's correct. Because the fundamental thing is that what is the accused person doing in custody? What investigations are the police carrying on? But it's not to say that if there are no further investigations, automatically he should be admitted to bail. No. If there are no further investigations, or if the police are being tardy in the investigations, the judge will admit the person to bail, but will set conditions. So where it is palpably clear that he is a flight risk, maybe he's a foreigner, so he has every incentive to run out of the next border, the nearest border, the judge will set conditions that will make sure that he doesn't escape. So it's very good if you ask these questions. We should make it clear. The fact that you have a right to bail doesn't mean that automatically you'll be out. there are conditions to be met reasonably. The judge will look at the circumstances of the case and assess the accused person, or if he has not yet been charged, the suspect, and set certain conditions to make sure that he doesn't step out and escape.
Well, let me remind you all, you beautiful Guarantee Trust Bank customers, do you know that you can buy airtime from the convenience of your own home or office using the GT top-up service by dialing the short code star 737 hash, star 737 hash. Guarantee Trust Bank is rewarding customers who are yet to activate the GT top-up service from Monday 15 February to 14th May 2016. The first 20 customers who activate the service daily and buy a minimum of 20 Ghana cedis airtime on any network will be rewarded with 5 Ghana cedis worth of airtime. To activate the GT top-up service, dial star 737 hash, star 737 hash on your mobile phone, enter your GT bank account number. You're then required to key in a 4-digit secret PIN and confirm it to complete and activate the process. GT Top-Up is the most efficient and reliable means to buy airtime for yourself, family, and friends anywhere and anytime. The short code is star 737 hash. Remember, terms and conditions apply. Guarantee Trust Bank, wouldn't you rather bank with us? Coming straight back. Thank you very much for staying. And non-bailable offences struck out. And that's a major legal landmark, and the gallant lawyer who fought this fight or stood his ground, lawyer Martin Pebu, is here in the studio discussing with us. But as I said, all throughout I'll be wishing mothers, and this is to my two lovely sisters, Yeni Majampo, happy Mother's Day, and yes, Dan Sumisa, happy Mother's Day to you. But back to studio. Martin, so compensation. Would it make it easier for compensation, or how is it going to work?
Yes, so the court, knowing that this decision could lead to a floodgate situation where all those who have suffered may turn up in court and say they want compensation for having suffered, the court made it clear that the striking down of the law should take a prospective effect, meaning that it would take effect from yesterday into the future. So that means that for those who have suffered under that oppressive law, haven't stayed in custody, though we all knew that law was unlawful, they can't claim compensation. No.
Are you going to go back and say, no, they have to be paid?
Yeah, so looking at it means it's just not possible, because all of the judges were clear that the law is not taking a retroactive effect. So if you suffered under this law for all this year, and there are thousands of people who have suffered, no, you have no right.
So the 200 people in Nsawam now, I mean, can they get on the phone and call their lawyers and say, hey, go and find me bail because I'm not supposed to be here?
Yes. Now that with the law having been struck down, yes, there's an opportunity. There's an opportunity for them. But of course, as I mentioned, each individual applies, and on the basis of the merits of his case, he may be granted or the bail may be declined.
So those, I mean, the chickens and the sack of cassava being in remand, I mean, those ones, I'm sure they may be, I don't want to say they have to, but they may be eligible for bail. Yes,
those ones, they are eligible. Yes, stealing offences, they are. We'll place emphasis on the alleged rapists, murderers, narcotic drug offenders, terrorists, the pirates, and then treason. Yes, they were the hitherto non-bailable ones, so they now can apply for bail as of right. That's the difference. They don't have to show that I'm sick, and you don't also have to show that, the trial has been too long. The question is that once investigations have been concluded, you are just in Nsawam. Our law is very clear that we shouldn't throw suspects or accused persons into custody as punishment. So, based upon that, let them come out. So the law is very clear. Don't use bail, denial of bail, to punish. So we'll show you where power lies. We'll consign you to prison till this case is finished. No, that has been struck down.
So, I mean, are there, let's say for murder, the reasonable time for investigation is 3 months. For narcotics, is 1.5 months. For maybe piracy or treason is 4 months. Are there some prescribed timetable for the lawyer to be able to say, look, my lord, it's only murder, it's been there for 6 months, it's way past the prescribed investigation time?
Generally, there's a range, as you rightly said, there's a range depending on the offenses. Yes, so hitherto the range was too wide. Earlier on, I mentioned that there are some cases that I could open in the law books and show you 2 years, 2.5 years, and a judge could tell you that, oh, it's not long enough, meaning that go on. So generally,
do the investigation.
Yes. So generally, your chances of getting bail was higher, far higher, if you did at least 3 years. That is what has been struck down. So starting from yesterday, we are now going to get a new set of cases, which we call our jurisprudence. Now that the judges have been freed and been allowed to exercise their discretion, the old cases will not be that useful. Now they are free. In law, we say that when it comes to exercise of discretion, no two cases are the same. So we are not going to rely on all those old cases. Now the judges, their discretion is unfettered. Of course, when I say unfettered, what I mean is that they are supposed to exercise it reasonably in accordance with Article 296. So the old cases are not useful. So it will take a while for the judges to begin to flesh out the new time periods.
Martin, if you look at our police ratio, I mean, ideally we should do 500 to 1. We're not doing too bad. I think we're doing about 800 to 1. I mean, is it going to put undue pressure on the police now? Because, I mean, I remember 5 years ago, maybe it's too long, but somebody went to report that a daughter had been raped, and the police asked the man, look, go and bring him. So the guy also picked a taxi to go and bring this rapist. And I mean, if the guy is a suspected rapist, I mean, that's a dangerous person. But for the love of his daughter, got a dropping, went to this guy's house and brought him. Now, what I'm saying is, there are cases where police say, well, we don't have a car, it's too far, we can't get there. And they have to do an investigation in this short period because otherwise, the suspected criminal goes free. Yes,
you are right. That's a very legitimate concern. So the court even addressed this particular point. The CJ made a point, and rightfully so, and in which the other judges concurred, that the government must resource the police. We need to commit more resources. As you rightly said, the UN standard says that we should have 500 citizens to 1 police, and we are doing 1 to about 750 or 800 thereabout. It means that, yes, we are lagging behind, okay? Something should be done. We need to prioritize. Security is one of the foremost needs. It's basic. It's fundamental. So the government needs to resource. And now you are well aware, there are so many thousands of graduates who are unemployed. We need to recruit more. And then we need to change the systems. We need to monitor so that from day one, when a case is given to an investigator, it should be given time limits. They should be monitoring. In that period, we should be sure that an investigator who is investigating a case is not proceeding on leave. It's not proceeding on transfer. It's not proceeding on peacekeeping. It's not proceeding on certain courses. So these are the changes we need to make. So we need an overhaul of the way the police conduct investigations. We need an overhaul of the way Attorney General conducts the prosecutions. So it's good. The decision will make us sit up. Yes.
What has been the general acceptance on this ruling? Are people happy? Are people say, we are doomed? Look, where are we going to step next? What's been the general feeling about it?
I can tell you straight away, amongst the lawyers, there's so much excitement. We all feel a new leash of freedom. Yes, wow. A new sense of freedom. Today when I went to court, I was getting congratulations all over on the phone. Oh, yes, because, you see, the mistake we're making is that it's not as if this law is in vacuum. This law is actually a momentous step towards our quest for development. Development is about people, first and foremost. It's not about hospitals and roads only. It's about the people. So where you have bad laws that on any suspicion, a person will be thrown into custody for upwards of 3 years before he can get bail, that is not development. You've built the roads and hospitals, and yet the person is in custody. What is he doing? Where is he to enjoy? So we shouldn't look at it, this decision as an isolated case. It's actually a huge leap in our quest for development. In the UN indices for development, the human rights and then this and the standards of living. Yes, there is the measure of the about the quality of the law. What I mean is that there is this report that Justice Honenuga referred to, Court of Appeal judge, that about 3-4 years ago, there was a UN report that indicted us for these remand prisoners. And these non-bailable offenses contributed hugely to that number. The UN indicted us that our law wasn't good. Why do we keep so many people in prison without fair trial within a reasonable time? So it's the case that lawyers are excited, but I've also seen lay people who are going about saying that, oh, Martin, this law, we are going to leave criminals alive, we are going to allow rapists to roam our streets freely. That's not true. I keep mentioning that if we have evidence against these alleged rapists, these alleged murderers and the rest, when they are admitted to bail, those affected will pursue the police and the attorney general to make sure that their trials are conducted. So it's early days yet, and I believe the system will do self-correction, just like we do in economics. The markets correct themselves, then the system will correct.
I'm sure from Monday onwards, your phone will be flooded with people who will be calling you and say, listen, my brother has been in his home for the last 3 years.
Exactly. It's even started. Yes. It started. Yes. People are saying, oh, yes. Oh, this man is being in custody for 4 years, 5 years. And I say, okay, then bring it on. Let's see. So to speak, for lack of a better expression.
This remand issue, I mean, there are cases where the victim decides that, listen, I don't even want to pursue this case anymore. But the state then says, oh no, it's still a crime and therefore we are going to pursue it. In that case, can the state still hold you or the state should still let you go?
The state should let you go. So you see, Nana, what is at play? That's how it's good you've summarized it that way. On one hand, theoretically, it's true that it is the state that has control of the proceedings. Because it's a crime, it's the state that decides whether to stop or to continue. But also practically and strongly recognized in our jurisprudence is the fact that when the complainant says let go, usually the state should respect the wishes of the complainant. So it's only in exceptional cases that the complainant will say let go and yet the state will continue. No. The accepted jurisprudence is that generally when the complainant says let go, the state is to let go. Unless generally where you find that maybe the complainant who is now saying, I don't want this case prosecuted, was probably induced by some monetary or private gains, then it means that that complainant is perverting the course of justice.
Okay.
But otherwise, when the complainant says let go, that should be it.
In that case, where are witnesses and evidence going to come from when the guy says, I don't want to pursue anymore?
That's interesting. The jurisprudence in our law on one hand, the law says that even if you refuse to come and give evidence, we can subpoena you. Okay? But the question is, if you subpoena the person and you bring him in, practically, the evidence that you get, there are so many problems. You can subpoena him. So if we're going theoretically, when the complainant and the witnesses say, I won't come, we can use the coercive powers of the court to bring them in.
Hostile witness.
But as we normally say, you can force a horse to the river, but you can't force it to drink. So you see that usually. So once the complainants and the witnesses express their desire to let go, sometimes you find that the state wants to drag its feet and prolong the case a bit. Usually it's to send a signal to the public that they will let go, but eventually the state has to let go. You remember the KKD matter?
Sure.
The state, there was this posturing that, no, we will go on. Yeah, they went on for 2-3 months, but eventually they had to let go. Yes.
Well, we're going to go for a quick break, and then when I come back, we'll look at if it will decongest our prisons, because that's another thing which is really, really hurting us. The congestion in our prisons and the health conditions and facilities. Will this law maybe help the prisons? Who knows? Coming straight back. Well, thank you very much for staying. And are you a customer of Guarantee Trust Bank? Do you know that you can buy airtime from the convenience of your home or office using the GT top-up service by dialing the short code *737#? Guaranty Trust Bank is rewarding customers who are yet to activate the GT top-up service from Monday 15 February to 14th May 2016. The first 20 customers who activate the service daily and buy a minimum of 20 Ghana Cedi airtime on any network will be rewarded with 5 cedis worth of airtime. To activate the GT top-up service, dial *737#. On your mobile phone, enter your GT bank account number. You are then required to key in a 4-digit secret PIN and confirm it to complete the activation process. GT Top-Up is the most efficient and reliable means to buy airtime for yourself, family, and friends anywhere and anytime. The short code is *737#. Remember, terms and conditions apply. GT Bank, wouldn't you rather bank with us? Martin,
Yes.
our prisons are really congested. Would it make any significant change, or would it make any change in terms of people who are needlessly bagged up?
On one hand, some may say it may be early days yet, but on the other hand, being a crooked optimist, I think it's going to make a significant change because, as I mentioned, a lot of those people in there on those charges have spent over a year. So once you've spent over a year and you apply and you can meet the conditions of the bail, you're supposed to be granted bail. So, I mean, presumptively, it's going to make a significant change, very significant. Yes.
Looking at the posturing of the police, I don't know if they take it personal or they take it overly professional, but we've had cases here. I had your colleague Francis here, and, you know, apparently sometimes when you go to the police, the reception,
Yes. It's not the best at all, to put it mildly. Yes. Yes. I think it's a reflection of our society. Sometimes it's a reflection of the training they get. It's also a reflection of stress. You know, it's quite a complex mixture. You'll find some who are very nice, extremely professional, and so also you find some who are very discourteous and not pleasant at all. So that's what I say, it's a reflection of several factors. So with this, as we say, now that so much will be brought to bear on them, we expect changes so that the police service will have to, as we said, make changes in their protocols. There should be a queuing system. Because sometimes, to be candid, some of the investigators are overwhelmed. They have too many cases at a time. Too many cases being prosecuted at a time. There should be a queuing system where, let's say, an investigator has been given 6 cases. He must finish those before he is assigned to fresh cases. But from the way it is, you find one investigator, he's here, he's there. No, it's not the best. And also in the courts, we need this very much. There is no general queuing system. At least from the little I've read about certain jurisdictions, when each case is presented, it is booked, and then there are timelines, and there should be an end date. You see, even in Ghana, this is our case with Côte d'Ivoire. You see that as soon as the case was presented, we're giving timelines for all those things, and there's an end date by which judgment should be given. That is what Ghana seriously needs. We need to develop that queuing system so that if the first murder case has been presented, it must be prosecuted and finished before the next rape case. But right now, there isn't that well-organized queuing system. And you see, coupled with this our lack of respect for time, it just makes it so bad. Yes.
The other people or the other group of persons who really face the wrong side of our justice are poor people. I mean, they are dealt the biggest blow. Are they still going to be dealt this big blow, or with this law they will benefit?
Oh, my brother, they are supposed to benefit. At least on paper, they are supposed to benefit, because right now with this new law, it means that every person is entitled to apply. But that doesn't mean automatically it should come out. When you apply, the judge will review the case and see how long have you been in custody. Okay. So how much time does the police need to investigate? As I said, once the judge discounts the time that the police need to investigate, then the next question is that, okay, so Mr. Kojo Ba, what do you do? They'll look at your circumstances. And then once they find out that you are not a flight risk, the judge would admit you to bail. So the very potent, one of the crucial elements that the judge or factors that the judge will consider before granting bail is about the flight risk. They do, yes, it's not scientific, but generally we assess and see, looking at the crime from the circumstances, does it look like this is a person who will run, who will abscond? If the facts show or if the circumstances point to a likelihood of a flight risk, then such a person may not get bail. But, my brother, I think a lot of those poor people will benefit. A lot, a lot.
I don't have the statistics, but you know, I can bet that the 200 people in Nsawam, you know, a huge percentage of them will be people who don't have too much of a network.
That's correct.
And those who don't have big bank account. But yes. I mean, you ask yourself, why should they be denied justice? I mean, are they also not Ghanaians? Why would they be denied justice?
Well, that's it. It looks like it's like natural selection. Yes, survival of the fittest. Yes, it's a form of natural selection, you see. So those who are stronger come out earlier, generally, in terms of applying for bail, because they can afford, they can get very competent lawyers to apply. But the poor ones, but we too, I think to be fair to the system, that's how come they brought the Justice for All. So even for those who can't afford, at least the Justice for All project is helping them. Okay, but generally you're right that the poorer ones are far more vulnerable, and it's the situation in a lot of other jurisdictions. So it appears, well, it's a reality of life. I'm sure in America you are familiar with this concept of celebrity justice. Celebrity justice, where generally the American population, they will tell you that the celebrities get soft justice and the poor get, you know, there are so many black poor men, so many of them, almost 1 million in jail and all those things. So if you compare, generally you may come to a conclusion that poor people are far more vulnerable
when it comes to justice.
Yes.
If I wanted to apply for my own bail, I mean, I can't afford a lawyer, and I wanted to apply for my own bail, thanks to you and your new law that you passed, is it possible?
Yes. Yes, under the law is possible. And also I think we should mention this. The prison system, the prison authorities with the British High Commission have a certain project in which they've trained some of the prison officers to do applications for bail. So they help the prisoners and the remand prisoners to apply. Yes, so some of them come and they move their applications. So it's brought before the judge, he reviews the case, and then if it thinks that there is merit, the judge grants.
Well, let me catch up with some of your messages. Happy Mother's Day to my lovely mom, Mary Egan, a.k.a. Abba Esun, in Adiembra Sekendi, Adiembra K30 in Sekendi. So happy Mother's Day to you. This one says, Nana, I think this ruling somehow good, but very bad, since people can easily run away when they are granted bail. From Musa in Koforidia. This one says, to me, the scrapping of the non-bailable offences from our status books will throw the country into total confusion and anarchy sooner than later. The writings are clear on the wall. This is from D.Y. Enchi. This one says, this is from Zach from Tamale, S.A. Zach from Tamale. The ruling is wonderful because instant justice will now be the order of the day. We thank God. God can now kill. God, we can now kill criminals on the spot. Zach, how did you understand this ruling? This one is Mate Bam from Segu in Nangpanduri. Hey, Constable, the lawmaker isn't above the law. If you, as an agent of change to deal with crime, and other offenses have done this, then this is serious. So you see, there are those who are happy and there are those who are skeptical. Council, we are proud of you. We are proud of you as of lecturer.
Okay, yeah, I lecture.
Oh, you
Yeah,
lecture.
so maybe
Okay,
that's a
Kafu in
student.
Central University.
Okay, yeah, that's my
Okay.
student.
Okay. Well, Kafui, we're all proud of him. And this one says, oh no, this has got nothing to do with us. Good evening, Nana. Good evening. I'm of the view that the Supreme Court should have given a time limit at which persons who commit these crimes can be put on remand. We should not for that. There's some people that may find themselves at the wrong side of the law with regards to these types of crime and cannot control or conduct themselves well, hence need to be confined for psychologists to talk to them. McLean. So, you know, McLean is wondering that maybe somebody may be insane and then you grant them bail.
There's a way to weave sort them out. Yeah, separate the wheat from the chaff, so to speak, in a way.
Well, this one says, looking at the state of our prisons, I can't but agree with the ruling of the Supreme Court. It's really an abuse of the fundamental right to sleep in our prisons for just one day, more especially when you have not been found guilty. This is Oredu in Kumasi. And this one says, Nana, this judgment is very good for our criminal jurisprudence. It will also help further decongest our prisons. Kudos, Martin Pebu. He is my criminal law lecturer. We love him. This is Fifi Odoko Official Town. Okay, and this one says, Happy Mother's Day to my mom, Madam Ellen White Mauto of the matron of the Valley View University. I love you and may God give you long life. From your lovely son, Emmanuel Godwin Entua. In fact, I really support this. This is all, again, from Martins. This is from Emmanuel. In fact, I really support it because it really infringes on the right of people who have not done anything but are just suspected for committing a crime. For the non-bailable law should be taken out of the system. This will help our very court work first on issue, even if the victim taking out of the prison, they don't get anything but rather waste their time. From Ochiame inside Jakbe Chrome. People are worried about this time limit. Is it also in the bosom of the judge now?
Yes. Remember earlier on I said that with this new law, okay, it's up to the judge to look at the facts of each case and determine what is reasonable. So it's early days yet. So let's wait and see how it goes, case after case. So after a number of cases, then we will see the general range. The old range was very bad. As I mentioned, the old range was very bad. Yes, 2 years, a lot of the time they say 2 years wasn't good. Of course, I also admit I've seen cases in which 1.5 years you could get bail. But those were few. Those were generally few, at least with my experience. You see, but with this new one, we expect the time limit to come down substantially. And also, across board now, it's a right you can apply. But under the old law, you had to wait. You had to be abused. You see how the old law, that's Article 14, Clause 4, says that when your trial has been unreasonably delayed, then you can apply, and the judge can discharge you. So it means that wait and be abused before they grant you bail. No, now it is such that from day one, the judge may just give some time for investigations. As soon as that is done, bail can be granted, which is far better. Good law.
Well, this one is Nana from Nkoko says, this is my first time of watching you. I really love the conversation with the counselor. I'll watch your program always from now onwards. Well, from Monday through Friday, 9 p.m., switch to Joy News and watch PM Express. And thanks for tuning in. We're going to catch a break. And then when I come back, I'll catch up with all your messages that are coming. I'll do my best. Don't move. Well, thank you very much for staying. This one says, lawyer Martin Pebu has made history. His name will go down in history forever. This is from Opomba in Tema. This one says, please, what are people who the police keep in cell for more than 3 days just for fighting with a friend without bail? Name innocent. For I know someone who was kept in a police cell for more than 4 days because he alleged to have insulted a man who ordered the police to arrest him without bail.
That's illegal.
It's illegal. Law, council says it's illegal. This one says, I am Raj from Kumasi. The law is good, but I hope the accused persons don't commit suicide because of the fear they will be thrown in jail for years. No one is above the law. Murderers should be jailed 95 years. James Bond, Nana Kwesiata, Asim Fosu. Okay, all he says, he just proved that he actually committed the murder. Good evening, Nana. Look, I am now happy because our prisons will be decongested. This one says, Nana, ask the lawyer if his daughter is raped, what would he expect from our judges? This is Nana in Tema. So, you see, there are people who are concerned. You know, they're not very happy with this ruling that you've befelled on them.
I think it's fairly balanced, but maybe let's take the concerned ones. We should go back a bit. Yes. Yes, the one who says, if my daughter, yes, I have 2 daughters, is raped. You see, with the education I've had, the law says that the man is innocent until proven guilty. So what we expect is that when we go to
even
court,
if it's blatant.
Yes, so be it, because he's asked, when the trial starts, they will ask him, except murder. So for murder, even if you see him shoot a man to death, even if he goes to court and says, I'm guilty, by law, the judge must write not guilty, so that the state should go ahead and prove their guilt, okay? But apart from murder, okay, those ones and treason, when it comes to rape, if he says he's guilty, so the judge will convict him on that very day. Now, let's explain this. So, as I said, if somebody were to rape my daughter, so if it's a daughter less than 16, we call it defilement, above 16, rape. So, either rape or defile my daughter. What I'm expecting is that when we go to court, the judge would remand him for a reasonable period for the police to finish their investigations, okay? Then, beyond that, if there is evidence, so beyond that, he's admitted to bail, stage 2. After the investigations, he's admitted to bail. Meanwhile, all this while, the trial should go on. So stage 3, once he's out, it means I'll be concerned. So, and even before so I should step back a bit. At stage 2, at the time they are going to admit him to bail, the major concern will be that, will this man stay to stand this trial? So we'll check. Is he married? Has he got a decent job? Okay. What are his social ties and all those things? Okay. So once the judge assesses all these things and comes to a conclusion that, yes, we should admit this person to bail, that is the law. That is the law. Let's not for one moment assume that, oh, we're just doing it in such a way that, excuse me to say, alleged criminals will have a field day. No. What we are saying is that they are our brothers also. Let's go back to the example we gave. Let's look at this huge talent. See how much he's been an influence on the media platform. Look at Kwaokese. We could go on and on. So we should be careful that we just don't say because we want to make sure that justice is done, we'll do it roughshod. No, there is what we call due process. These persons we are calling alleged murderers and rapists, let me also say that some of them live with us. Some have already been granted bail under the some private practitioners have gone to court and have got bail for them. Others too under justice for all. And they live with us. We don't have any evidence that as soon as they came out, they've caused us more harm. Of course, it's also true that in every country, there is what we call the repeat offenders. You see, yes, repeat offending is it's a reality in life. Yes, it's a reality in life. You can't avoid it. But I must say that maybe Ghana, perhaps we are not gathering the data well, but generally from the reported cases, ours is very minimal. Repeat offending is very minimal. You go to America and the rest, you have higher figures. So I'm encouraging my brothers and sisters to look at the positive side. We have people who have been admitted to bail, though they are alleged to have committed murder, rape, defilement, and the rest, and they live with us. So have we experienced those fears that they are already talking about? No, then we don't have evidence. So it's not new. We have some of them living with us and now attending their trials.
There was a case quite a while back, and I think they two gentlemen who work in a mining company, I think they stole about $3,000, or I've forgotten the amount. Anyway, one got his trial, went to court, served his 4 years, came out, and then the other one was on remand, waiting for his day, in court. I mean, so a law like this would definitely
admit him to bail once,
or trial.
Yes, yes, but once he spends some time in custody beyond the investigation period, the next thing is that
it is deemed you served your sentence.
No, not necessarily. Beyond the investigation period, as we said, we expect the investigation period to be short. So beyond that, he will only be in remand now under the new law, okay, if only it is assessed that he's a flight risk. Otherwise, he has to come out and breathe some fresh air, and then as and when the state is ready to prosecute him, the prosecution will go on. You see it? Yes. Because if they have finished investigating, and he's still in custody, the next is that, why is he in custody?
No, there was two of them. So one got tried, got sentenced,
yes,
came out, but the other one was still on remand, waiting for his day in court. So that, like, the two of us go and steal this.
Oh, okay. So one admitted guilt. He must have admitted, because if you are together, you have to be tried together. So from what you're saying, in all likelihood, it means that the one who has been sentenced from day one
said, I'm guilty. And the other one too.
If he says he's not guilty, then that one, he has to wait for his turn.
For the investigation to go on.
Exactly. And then also when they are ready, then the trial will start. As I say, there's a huge backlog.
But I mean, you know, and you say you have cases where 2.5 years. So let's say if this is a rape case or something. I mean, I'm no police officer, but I mean, what at all would you be investigating for 1 year and 2 years? I mean, but the judge is a very learned person.
Yes.
Don't they get concerned that, you know, constable, after 2 years there, whatever it is you're trying to find, I mean, even if it was a baby, you know, is about to go to crèche.
Very good. You are very right. Yes. So it is a case that some are very concerned, so they grant bail at what do you call it? They don't wait till after 2 years. But others too would insist that no, 2 years is not unreasonable delay. You see, from the older cases, those we carried forward from the 70s, yes, that's where these 2 years, 3 years came from. So some stuck to them. Others too, the bold spirits, 1 year, even depending on the facts, they could grant. You see, but now with this new decision, we don't expect to have so much disparity and uncertainty. And when you talk about your earlier question about the police, yes, it's worrying. Sometimes you're worried that, the policeman has been tasked with a case, and at the same time, he's been allowed to go to peacekeeping without proper transfer to somebody to take over. This same policeman is allowed to go on leave whilst the investigations are pending, or in the meantime, he's transferred, or they say he should attend a course, and then the accused is in custody. So we expect wrong. These things to stop.
That's just wrong. Nana, please ask for me. I've been expelled from my job. Can he help me? This is Sam from Takwa. I am not certain with my judgment. Can he help with my issue? We'll call him privately, and I'm sure he can. I'm sure he can help you. There was a happy Mother's Day. Wish here that I wanted to do for you before I close. There you go. This one says, Happy Mother's Day in advance to my mother, Mary Akosia Jima of Akim Achiase. Kudos, Lawyer Martin. You have made the real freedom in our emblem felt among the vulnerables in society. Well, folks, I think that's all time would allow us now, but thank you very much. You've done a yeoman's job.
Thank you.
Keep the fight on, keep the fire burning. Thank you all who sent your messages in. And thank you very much to GT Bank and to all the mothers in GT Bank. We wish you happy Mother's Day. And to all mothers out there, wish you beautiful, beautiful happy Mother's Day in advance. As you say, Monday, we'll be back to do this all over again. But right after News File, all those who missed it, tune in again and watch PM Express. Lawyer, thank you very much and congratulations.
PM Express was brought to you by
Guarantee Trust Bank. Wouldn't you rather bank with us?